Hi, in this presentation, we will discuss about patent post-grant review and reissue of patent. First, let us discuss patent post-grant review in US. A patent post-grant review request or petition to cancel granted claims as unpatentable can be filed by anyone within 9 months from patent grant. Patentee then can file reply to review petition. Director USPTO must find a prima facie case of unpatentability in post-grant review petition. Patent Trial and Appeal Board conducts post-grant review petition, a review of the petition. Burden is on petitioner to prove unpatentability during review. Settlement on claim scope is allowed by parties with approval of director. So if director approves, then parties can make a settlement on claim scope. Appeal by either party against board decision is allowed to Federal Circuit. And issues decided or settled during post-grant review may not be raised in later filed litigation or court cases by either party. Now coming to patent reissue in US. 35 US Code Section 251 authorizes the reissue of defective patent on patentee request whenever any patent is deemed wholly or partly inoperative or invalid by reason of defective specification or drawing, or by reason of patentee claiming more or less than he had right to claim in patent. So reissue provides an opportunity to patentee for correcting errors and ambiguity like defects in specification or drawing, or maybe patentee has claimed less or more than entitlement, which may be because of attorney's misunderstanding about invention during drafting and prosecution of patent application. Maybe attorney has not understood the invention fully. That's why error was made during drafting and prosecution. So that error can be corrected during reissue. Omission of reference to earlier application on which priority is based may also be corrected during reissue. Broadening reissue application for patent claims supported by specification or description in original patent application should be filed within 2 years of grant of original patent. Means a broadening claim can be filed during reissue if that broadening is allowed by specification or description in original patent application. If the broadening is not allowed by specification or description in original patent application, then broadening of claim will not be allowed. And if somebody is filing for broadening of claim during reissue, then he should file within 2 years from grant of original patent. In other cases which are not broadening the claims, the request for reissue can be filed at any time after patent grant during life of patent. Whatever surrendered previously in original examination of patent cannot be reclaimed during reissue. No new matter shall be introduced into reissue application. So during reissue, new matter cannot be introduced. Director shall reissue the patent on surrender of original patent and payment of fee required by law. And patent term of reissued patent will be remaining term of original patent. Now coming to intervening rights after reissue. Reissue cannot allow patentee to capture subject matter where infringer relied upon original patent scope. Means if somebody has developed a product which was not infringing the originally granted patent claims, and now after reissue, if it is infringing the reissued patent claim, then the person has intervening rights. If making, using, or selling something which is not infringing the original patent claims prior to reissue, then there are absolute intervening rights, and there may be no infringement claim in that case. If the product is not infringing the originally granted claim, but now may be infringing the claims after reissue, then person is having absolute intervening rights, and maybe there may be no infringement claim in that case. If someone has made substantial preparations in planned product prior to reissue and no infringement of original claim is there by planned product before reissue, and after reissue, if that planned product may be infringing the reissued claim, then there are equitable intervening rights of that person, and courts will decide on equitable basis for infringement by planned product post reissue. So that's all in this presentation. Thank you very much.